All right, this is case number 21151422. This is Enhanced Center Interventional Spine versus Allstate Insurance Company, and Allstate Fire and Casualty, Allstate Property Casualty. The matter is set before the court for review. The parties had indicated the case was set for case evaluation. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Richard Brewer, P31124 on behalf of plaintiff.
Right,
Good morning, Your Honor. Brandy Anderson appearing on behalf of Allstate.
All right, good morning to you, Ms. Anderson. Your P number for the record, if you will, ma'am.
70876.
All right, thank you, counsel. All right, so somebody update me regarding this matter. I do know that it was referred to case evaluation. That was sometime back in December. So talk to me, give me an update if you want.
Your Honor, we have a case evaluation date of March 29th.
So it's still pending, huh?
It is.
Correct. Yeah.
All right, well, I'm constrained to think that an adjournment might be appropriate under the circumstance. Hopefully, the case evaluator will work on helping to push this towards resolution. Given that the parties seem to express an interest in the same, I will find that there's good cause to adjourn this matter over beyond that date. So I'm going to go ahead and set it over in the month of April, the second week. Let's see what it is.
April 12th.
April 12th, 4/12/22, and that's going to be at 9:45 p.m. I'm setting that for review, and we'll take a look at everything at that.
Thank you, Your Honor.
I'm sorry, Your Honor. What time did you say?
9:45 a.m.
Okay. Thank you, Your Honor.
Thank you, Council. Respectively. Have a good day.
You too.
Also.
The court now looks to case number 21149538. This is Albion Refunding LLC versus Otis G. The matter is before the court on an application for entry of judgment by default. I have a note in my file regarding an agreement regarding a conditional dismissal. Your appearance for the plaintiff in this matter, please.
It's Craig Fay, P81401 for plaintiff.
All right, thank you, counsel. Good morning to you. I'm looking now for Mr. G. If you want to say something at this time, sir.
Yes, I've been, since I got this notice, I've been trying to get in touch with somebody to find out what it was about. And I have no idea what this is about.
I have no idea why you're talking. I didn't ask you to talk. I asked you to identify.
Oh, I'm sorry. I thought you asked me to say something.
Yeah, say something. Tell me that you're here. All right, so what is your name, sir?
Otis G.
Thank you, Mr. G. Just one moment, sir. Let's find out what's going on here. All right, Mr. Fay, I see that there is an application for entry of judgment by consent, and something must have happened somewhere along the line, because I see Mr. G. It appears he signed that, and you signed it. It's $849.89. So let me start with counsel, Mr. Fay. Update me as to what's going on here, sir.
I guess we're kind of in the same boat. We weren't sure. We did submit the consent judgment. Payments are being made. We were just waiting for, I guess, the consent judgment to be signed off on.
Okay. All right. Is that about the size of things for you too, Mr. G?
To be honest with you, Your Honor, I still have no idea what this adjudication is about.
Okay. Well, it looks like you signed off on a document saying that you owe some $849.89 of that. You agreed to pay that at $100 starting in the month of October. It looks like you've already been paying on it, right?
Okay, okay, yeah, I have.
Yeah, that's what this case is about. I don't know why it's back up, but perhaps because I had a note in the file, something about a conditional dismissal But I see now that the parties have a resolution. I'm going to go ahead and sign that. It means what you've already been operating on is formally an order that I'm going to sign today. So there's nothing in addition or nothing that changes about that. And apparently, a part of the agreement is already paid out.
Okay, could you tell me how much is still owed on that?
You have a balance, Mr. Fay? I don't have a balance. Maybe
Sure, it looks like the matter was settled for 600 and it looks like we received 500. So just, it looks like one payment just posted today. I know, I believe Mr. G set up automatic payments or posted
Yes.
checks. So looks like one payment posted today. So it should be one more $100 payment on the next scheduled date, and then the matter would be resolved.
Okay,
All right. Well, now I feel even worse that I have you here $100. So, all right. I wish you well. Everybody's on the same page. This case is resolved on the basis as previously indicated. So I wish you well. Good day to both.
Thank you.
Have a good day.
The court now calls case number 21-170617. This is TD Bank versus Tammy Everhart. The matter is before the court, set on for a hearing. This case is before the court after a order changing venue from the from the Redford Township Court. Your appearance for TD Bank, please. All right, do I have Everhart on the Zoom? Candy Everhart? All right, I do see in the file where the court did send out a notice to the respective addresses. It looks like neither party has appeared on this matter. Just one moment. That notice went out on November 23rd of 2021, setting today's date and time of 9:45 as a hearing this matter. That would have been, as noted in the body of the document, the status conference, and I said a virtual hearing, the correct Zoom address. Inasmuch as the plaintiff has not appeared in this matter, the case now will be dismissed. The court now calls case number 21-140786. This is Michigan Comprehensive Spine versus City of Detroit. The matter is before the court, set on for a motion, hearing on a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Philip Jaffe for the plaintiff, P25997.
All right, thank you, Mr. Jaffe. Good morning to you, sir. For the defendant City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Alfred Ashew, PA 2536.
All right, thank you, Mr. Ashew, and good morning to you as well, sir. I know I set a schedule in order in this matter, and I know that some discovery has taken place, and it looks like I recall the last time up that there had been a motion for summary disposition in the court adjourned that, and it seemed that I set that in September. So somebody update me. Tell me where we are in regards to this matter, Mr. Ashew.
Your Honor, well, I believe you said we should provide plaintiff with, I think it was at least 7 days to respond. That motion has been filed, but plaintiff hasn't had that opportunity to respond to the motion yet. I don't want to speak for plaintiff's counsel, but I think he would agree.
Is that about the size of it, Mr. Jaffe?
Yeah, when we were last in court, Judge, you set today as the hearing date, and you told defendant counsel to file his motion so that I had 14 days before the hearing date within which to respond. I only got this motion the day before yesterday, so I haven't even looked at it yet, much less responded to it. I'm not even sure the court has a copy of it yet.
And,
Well, it was electronically filed, so I don't know.
Yeah, I don't see, I don't see a copy of it. That doesn't mean it has been filed. I definitely, on the notice, it says that it's a motion hearing date. But suffice it to say that Mr. Jaffe has indicated that, that he's not had sufficient time to respond to the motion. It would make sense that the court go ahead and set it over so that he'll have opportunity to respond.
Your Honor, does the court prefer that I send a judge's copy via mail? Because I usually don't file electronically, but I just tried the system out, so I don't know if that gives you a copy or not.
That is usually a secure way of getting a copy to me. How long ago did you file, Mr. Asher?
I think it was 15th.
Yeah, well, I would, it wouldn't populate here that so I wish we could be so efficient. Okay. But that should be, the electronic filing should be sufficient, but it usually is going to be a 5 to 7 day turnaround before I actually have to respond. So that's what's going on. All right,
So Judge, given that, Judge, I would ask that you set this out far enough in advance so that when I respond, that you have enough time to have received the copy if it, if there's that kind of delay. That's all.
All right. I'll give you some time to do that. I'm disappointed that you received it 2 days ago and haven't read it yet.
I glanced at it, but with exhibits, Judge, it's over 200 pages. So even a glance took a good long while.
Mr. Asher, you got about 200 pages there with the exhibits?
There's one exhibit that's long, but the motion itself isn't very long.
All right. Well, brevity is always an issue. All right, so let's go ahead and give you a date. If I put it about 30 days out, that should be sufficient time to get all of these logistics together. So my clerk's going to give us a date in just a moment.
17.
3/17. And I'll set that at 10 o'clock a.m. 3/17 at 10 o'clock a.m.
That's fine. Thank you.
All right, thank you, gentlemen. Good day to you.
Thank you, Your Honor.
All right, the court is calling 21-162-989. This is Damon Banks versus Simpson, Onika Simpson. It appears the matter is before the court on a motion for entry of default. All right, so do I have Damon Banks on the Zoom? If you're on the Zoom, please say something at this time. Damon Banks. I have Onika Simpson on the Zoom. If you're on the Zoom, please say something at this time. Record should reflect that the court did set this matter on for a hearing on the entry of default. And essentially, this is a hearing on damages to determine the amount of damages that's being alleged. It appears that the defendant was a default, did not appear at the last hearing. Neither party has appeared on today's date. I'm going to give them the benefit of setting it over one time, and date will be generated regarding this matter. The court now calls case number 21-160-258. This is Progressive Marathon Insurance versus Marquise Barnett. The matter is before the court on an application for entry of a default judgment. The default of the defendant has already been entered where the defendant did not plead or otherwise defend this matter. For Progressive Marathon, if you want to Zoom, please say something at this time, council. Council for Progressive. Do I have Marquise Barnett on the Zoom? Marquise Barnett. All right, looks like the plaintiff has not appeared. The defendant did not appear in this matter and has not appeared at this hearing. The application for default has been submitted to the court alleging damages of $9,217.67, where there has been a previous entry of default and where the defendant did not appear, otherwise defending this matter, where the defendant has not appeared for this hearing. After the preceding notice from the court will enter the judgment by default at this time on the terms as per so ordered. The court calls 21-163-605. This is Joseph Pesty versus Carolyn Moses. The matter is before the court on an application for entry of judgment by default. The record should reflect that the default of the defendant matter. Today's date I'm set for a hearing regarding the judgment itself. All right, I have Joseph Pesky in this matter. If you want to assume, say something at this time.
Good morning, Your Honor. Joseph Presti. How are you?
All right, I'm good, sir. Good morning to you as well. Let me see if I have Carolyn Moses. Do I have Carolyn Moses on the Zoom? Moses, here to say something. Looking for a person living on Chandler Park Drive in the city of Detroit. It appears that Ms. Moses did not answer the underlying complaint and has not appeared for the hearing on today's date. Accordingly, now the court will enter the judgment by default on terms as prayed, finding that there's due to the plaintiff the total sum of $7,119.62. And I'm entering the order in that regard at this time. All right, sir, you'll receive a copy of the judgment in the mail.
Thank you. Thank you, Your Honor. Permission to leave, Your Honor?
Yes, sir.
Thank you, sir. Have a good day. Bye-bye.
Okay.
The court now calls case number 21-162-929. This is Credit Acceptance Corporation versus Jasmine Harris and Nicole Francis. The matter is before the court on an application for entry of default judgment. The record should reflect that the default defendant Jasmine Nicole Francis, I'm seeing now, was previously entered by this court on December the 9th, 2021. This is the application for entry of the actual judgment where the defendant has not responded or otherwise defended regarding this matter. For the plaintiff, your appearance at this time.
Good morning, Your Honor. Nadia Francis, P72322 on behalf of Plaintiff's Attorney of Record.
Thank you, Ms. Francis, and good morning to you. I'm looking
Good morning.
now. I'm looking now for Jasmine Nicole Francis. If you're on the Zoom, anybody representing Ms. Jasmine Nicole Francis Harris. Jasmine Nicole Francis Harris. That's the name. Living on Ewald Circle. All right. It appears that the defendant has not appeared regarding this matter, although the court did send a special notice with the correct Zoom address to the defendant's last known address. Accordingly, the court will enter the judgment now by default on the terms of the trade by the plaintiff. The total sum of the judgment is $10,731.63. The judgment will be entered at this time for that amount. So,
Thank you, Your Honor.
Thank you, Ms. Francis. Good day to you, ma'am.
You as well.